Hello, everyone, and welcome to another episode of the Real Estate Development Insights podcast, where we bring you ideas, experiences, and best practices from the real estate development industry. My name is Payam Nursalahi, and I'm your host here. My guest for this episode is Zev Zlotnick. Zev is a lawyer. Zev is a partner at a firm called Gardiner Roberts. It's a law firm, and they act on behalf of owners, developers, lenders, landlords, and property and asset managers of any type of multi-residential, office, retirement home, and retail properties when it comes to negotiating their sales and acquisition deals, sophisticated commercial leases, and any related agreements. And they also are very active when it comes to forming deals for real estate development projects and setting up funds, dealing with tier 1 lenders, schedule 1 banks, and you name it. They have a very wide range of services that they provide in this law firm. I wanted to have this episode with Zev because I know one of the things that I've seen throughout the years is the legal setup of a real estate development project is very key in terms of how you manage your risk, financial turnaround, the ROI, and the potential tax benefits that you might gain from they're having the right or, God forbid, the wrong type of legal structure. So in this episode, we dive deep into the importance of due diligence, what different types of legal structures or legal vehicles you have when it comes to forming a new or starting a new development project. What are the pros and cons of each of these structures? So Zev explains a whole bunch about those and provides inside tips and tricks and what to be careful about. We talk about the concept of a fund. What is an real estate investment fund, either being a REIT or somewhat of a smaller scale fund? And what's a blind fund? We talk about the concept of a general partner and limited partner, how that legal structure works. What are the roles and responsibilities of either party in that scenario? What does a lender look at when they're looking at funding proposed project, a real estate development project? What are the legal aspects that they want to see done properly to minimize their risk and liability on their front? We talk about different structures of ownerships and how to keep your ownership and keep your liability apart, trying to manage the risk when it comes to that. Different setups, different structures. And we also talk about some of the common mistakes that new, perhaps, entrepreneurs make when it comes to raising capital in terms of their structure and how to avoid that, and a whole bunch of other stuff that I'm pretty sure you're going to find helpful. You can find more information about this episode and our guests on our website, realestatedevelopmentinsights.com. That's all one phrase, and I hope you enjoy listening to this episode. Please remember to subscribe to the show, and even better, tell others about it. Thank you for your support. Hi, Zev. Welcome to the show. How are you doing?
Thank you. Pleasure to be on the show. Thank you for inviting me.
My pleasure. Thank you for being here. Appreciate the time. Why don't we go ahead and give a little bit of an introduction about you and your background, what you do, who you work with?
Okay, sounds great. So I am a partner in the law firm of Gardiner Roberts, LLP. We're a mid-sized firm downtown Toronto. It's a full-service firm, so we have a robust real estate department, corporate department, litigation, ancillary services such as employment, tax, IP, health law, transportation. Been around for quite a while. I've been for over 20 years now since I started. Wow. So it's the only home I've known. So I'm obviously biased, but it's for me, it's been a great place to work. We're mid-sized, but we're downtown. So, you know, as I always say, but we're more financially efficient and probably a little bit more nimble than some of the larger firms. And our client base ranges from anywhere from someone incorporating a company and starting up a business to selling their, real estate, North American real estate portfolio, $2 billion and in between.
So like you and I were talking before recording, our audience here and our goal for doing this podcast and similar content that we create is to make frameworks for people who want to get into development, who want to ramp up their game, and potentially our audience might have done some smaller projects, have done rows or flips or custom houses or splits and severances and stuff like that. And now they're trying to up their game. Hopefully, as we have listeners that are more seasoned but are looking to see what's going on in the market in terms of new vehicles, if you may, when it comes to doing larger projects. With that in mind, with that said, I'm hoping that we can explore different options and different avenues and different paths a new developer can take when it comes to defining a project, raising for a project, and all sorts of legal. Obviously, I'll follow your lead, but maybe walk us through some of the, want to be a developer. I want to be a developer for the first time. I potentially have a piece of land that I've managed to either tie up or I'm in the process of at least getting into the due diligence period. What are some of the key things that I need to consider from a legal perspective when I'm setting up the project from the get-go before we get even to the fundraising side of things? Maybe just let's talk about the legal structure.
Sure. So first of all, try not to sign anything until you've shown it to your lawyer. It should be obvious, but sometimes the deal is really hot, and people want to go ahead and they want to blow through it and get that deal signed up and tied up. But there's a lot of nuances when you're jumping, especially from, let's say, residential to commercial development. And I don't mean commercial in terms of office, any type of larger type development deals. Whether that's multi-commercial, whether it's mixed use, whatever it is, there's a lot more that goes into the nuances of the underlying agreement. Whether you're starting with a letter of intent, which is primarily just the business terms, or going straight to an agreement of purchase and sale, show it, run it by your lawyer. Will depend also what you're purchasing. A lot of people in the development game will buy income producing properties. They'll do an assembly or, let's say, a retail strip mall that potentially down the road can be a development project. And in the interim, it's producing income, which floats the property and floats the mortgage. That's great. That's ideal. Rather than purchasing a raw piece of land that is not throwing off any income and you have to pay the mortgage either from your investment funds or out of your own. That's obviously a lot tougher. But in any of those scenarios, there's going to be real property nuances, corporate nuances that have to be taken into account. So from the get-go, get a solid letter of intent, get a solid purchase agreement that you're comfortable with, that your counsel's comfortable with, negotiate that, and hopefully you'll be ideal business terms for you, and then you're off to the races.
So in terms of business terms that you just mentioned, obviously we have different types of legal setups that we can set up to properly do a project, right? I can probably go out there and pick up a piece of land or a property like you mentioned in my own name. There are multiple avenues in terms of legal ways of doing it, different types of corporations. Maybe walk us through that. What are some of my options? Like what are the things I should be thinking about? And maybe walk us through some of the pros and cons of those.
Sure. So I think before ownership structure, just in terms of the purchase agreement, letter of intent, the primary items that you should be looking for, obviously price, the business term, the price, the deposits. Try and get as much as you can on the due diligence side, because during due diligence and recognizing a lot of markets are tight, like they're not going to give you a ton of time to do your due diligence, but you want to do as much as you can before you waive conditions, knowing as much as you can possibly find out in terms of your zoning expectations, municipality expectations and requirements. The worst case and one of the most damaging things you can do is waive your conditions. Your deposits are they're hard money or non-refundable. And you find out afterwards that the municipality is actually going to want X, Y, and Z when you were expecting A, B, and C. Your density requirements are a lot less than the density opportunities are a lot less than what you envisioned. And now your money's at stake. It's already non-refundable. So try and squeeze as much as you can. And there's different ways you can do it, right? You can have a general due diligence period where all your general due diligence conditions are waived after 20, 30, 40, 50, 60 days. And you have a bit longer for, zoning, a bit longer for financing. Sometimes a vendor will be more amenable to that. If it's a tight market or a tight property, it's going to be a lot more difficult for you. And you're going to have to do a lot of your research that you possibly can beforehand. Sure that your zoning consultants, your planning consultants, those people are right out of the gate. They're doing as much as they can to get you as much of that kind of information. If, like I mentioned, it's a retail plaza or some property that's producing income, you're going to have to do your due diligence on all that income producing element. So if it's retail leases, commercial office leases, you're going to have to build in production of those leases into your purchase agreement, the ability to review them, tenant estoppel certificates before closing. You want those leases in place. You want to make sure that the leases are, even though it's not your long-term plan, you want to make sure the leases are producing the income that you envision them producing. And obviously, financing conditions to make sure that you can get the proper financing to purchase the property.
Okay, so I basically what you're saying is do a lot of legwork as much legwork as possible before even you get to the LOI or APS stage, which is good practice and common sense.
If you can.
And then, yeah,
a lot of sellers will be like, I'm not giving you anything until you sign your NDA, until we've got a deal in place. And I can completely understand that. But to the extent you can do some type of zoning analysis or rezoning analysis, development analysis with your consultants before, try and get that in if you can.
And that goes to be part of a bigger discussion that if you're going to do this, obviously you're not going to tomorrow morning wake up and say, okay, I want that parcel of land. You would have been studying a whole bunch of areas to see market conditions, zoning conditions, to your point. So Make sure you have done your homework before you come to the point that you actually need to consider signing. When you want to go through the signing process, obviously consult for counsel there and make sure you've got your bases covered. Okay, then walk us through there. Like now I'm go through purchasing of a property like you mentioned.
We found our property, $10 million purchase, right? I know I'm going to get financings for X. I know that my development costs, whether it's development charges through the city, etc., the equity that I'm going to need to eventually get my construction financing is going to be Y. So at this point, you're into the structuring side of things, right? I want to bring in investors. How do I bring in investors? How do I buy this property? So there's a number of ways to buy a property, and that's whether you're development or whether it's income producing, whether it's raw land, whatever your property is that you're buying, there's a number of different ways to own real property in Ontario. You can have it in your own name, which I would never recommend to anyone ever. I have actually had a couple deals where I acted for lenders and the borrowers owned the property. It's a multi-residential property producing income in their own personal name. Something goes wrong, they're suing you personally. It's the easiest thing to create a company and put it in place, even as a title nominee or bear trustee, with you being the beneficial owner. So never put anything in your own name across the board. It's a liability disaster waiting to happen. The next way you can do it is really just buying it in the name of a corporation with you as the shareholder. So that's not necessarily ideal if you're bringing in investors. What I've seen, the most common structure for the two most common structures for development deals, and any deal when someone's bringing in an investor, even if it's a syndicated deal for income producing properties, not for development, the most common structures are a limited partnership or a co-tenancy. I'll walk you through both of them in terms of what that structure looks like. Sure. On the co-tenancy side, you're basically partners with all your investors. All the investors are grouped as partners or co-tenants, co-owners, and they own the property through a bear trustee or a title nominee, with all the investors being co-tenants, being the beneficial owners of the property. So on title, there's a company, so liability is somewhat sheltered that way. And all the investors, like I mentioned, are co-tenants. And you structure that through what's called a co-tenancy agreement. Similar to what people normally would have, let's say, if you buy a business through a company, you have a shareholders agreement. It's a document that governs the relationship between the parties and includes, obviously, the title nominee that's holding title to the property for and on behalf of these co-tenants. So let's leave that aside for a moment. The second structure, which I think is actually a little bit more common than a co-tenancy, is a limited partnership structure. So in a limited partnership structure, there is a general partner, which is normally a corporation as well, that the principal, the promoter, the sponsor is usually the sole shareholder. And that general partner company, it manages the affairs of the limited partnership for and on behalf of the limited partners. It does everything. There's a limited partnership agreement that sets out the whole host of powers that the general partner has, to deal with the property, to pay bills, to take out insurance, to take out financing, et cetera, et cetera. And the other limited partnership are the limited partners, the investors. We invest, we are just limited partners. We take no active management role in the affairs of a limited partnership, and therefore our liability is limited. If something goes wrong, whatever it is, it's the general partner, which in this case is a company. So in of itself, it has limited liability. The general partner is the one that's on the hook. We investors are limited partners. And then you set out a limited partnership agreement that sets out the various roles of the general partner. Usually then there's the waterfall. And then both agreements can have the waterfall or the distribution structure. And we can get to that again in a moment. I guess the question is for anyone, what do I do? Do I go a co-tenancy route or do I go a limited partnership route? So a lot of it should be driven based on tax and advice from one's tax advisors and accountants. Like I've said, I've had clients who prefer a co-tenancy route, and that's because they generally have grander plans of rolling that co-tenancy up to the partners. It's usually closely held. So there's, a couple of or a few co-tenants, and they have a master plan where they're going to roll that up into some other company or some other structure in the future. So the co-tenancy is I wouldn't say temporary, but it's a structure that they want to put in place for various tax-driven reasons. For what I understand, limited partnerships are flow-throughs, which means that profits and losses can flow through to the limited partners. Initially, with the beginning of any development project, there are heavy losses. No one's making any money. You're just paying money out. Those can flow through to the limited partners that they can then offset within their own investment corporations against profits. Again, I know enough about tax to know that I don't know enough about tax.
Yeah, people should talk to their accountants when it comes to legal and financial stuff.
Absolutely. And the accountants, one's accountants or tax advisors in terms of structuring and setting all these, various structures up. So that's one difference in terms of the two, one consideration. Get that tax advice, make sure, you've got that proper advice to structure it. Another consideration is really just logistics going forward. When it comes to a limited partnership, the limited partnership itself is the beneficial owner of the property. And that makes a difference really in terms of financing. So whether it's the initial financing, whether it's construction financing, takeout financing, mezzanine financing, a lender has to take security against not only the registered title holder, but also the beneficial ownership of the property. And there's various reasons, but suffice to say, let's take it for granted that a lender is going to want to know who are the beneficial owners, and I need to take security, a charge of beneficial interest, or it could be that the beneficial owner will be a borrower itself. In a limited partnership, the limited partnership itself is its own legal entity. It is the beneficial owner. A lender will not go through the limited partnership to take security from the limited partners. Maybe they'll build in guarantees. It depends on the structure of the limited partnership. A lot of times, the principal behind the whole deal will give a guarantee. The limited partners don't have to. That's secondary to this discussion. But suffice it to say, the limited partners, the investors themselves, will not have to sign any documentation when it comes to any financings. Conversely, a co-tenancy is essentially, like I said before, on some level, not necessarily a legal level, but on some level, it's a partnership, a group of people or investors or companies acting as co-tenants in concert together. However, that means that the beneficial owners of the property are the co-tenants themselves. So when it comes to a financing, logistically, if you have 10, 20, 30 co-tenants, it could be a nightmare because every one of those co-tenants will have to sign a beneficial charge limited to their interest in the property, but a beneficial charge of their ownership interest as a co-tenant in the property. And that comes with the beneficial charge agreement. Generally, it has to be backed by an officer's certificate, a resolution, and an opinion with respect to that entity. So at the end of the day, it may make sense. And if someone has a co-tenancy of 2, 3, 4 investors, it's probably not a big deal from a logistics perspective. But if it's a widely syndicated deal, limited partnership from a logistics perspective probably makes more sense.
what I heard is that the co-tenancy, like you mentioned, is somewhat of a exception of a setup that either you have other plans or you have very few people that you want to get involved. And that's where you probably would think of a co-tenancy. But in general terms of investments and bringing in investors into your project, the LPGP or the limited partnership model is probably more practical, I think is the word, that you go through that model because from what I understood, basically the LPs, the limited partners, have limited liability. Like my assumption is that if your share, if you put $100,000 in and that's your liability, is that correct?
So liability in terms, yes, absolutely. Liability in terms of, call it piercing the corporate veil if something goes wrong, if there's a default on the loan, if there's an environmental issue, if there's fraud that's obviously not perpetrated by the investors themselves.
Right.
The limited partners, the investors, they're sheltered in terms of the money that they put in. That's at risk, but it cannot, you cannot pierce the corporate veil of the limited partnership itself to get at their own assets other than what they've invested into the project.
Gotcha. So if I'm the GP, if I'm the person who's putting together a deal, I've sourced the land, I've found it, I've tied it up, I'm putting this together, this structure under an LPGP setup. Is it fair that I can tell my potential LPs, limited partners, that listen, you're going to come in, you're going to buy into this investment, that's under your money is there, you have no liability other than the money you put in, except for what you just said. And at the end of the day, once everything gets said and done, then obviously the returns will be proportional to your share will be distributed. Is that a fair way of putting it?
Yeah, so you can. There's obviously a lot of nuances to that, and that's what's negotiated within the limited partnership agreement. And a lot of limited partners, investors will require that the limited partnership agreement state that our investment or our liability is limited to the amount of money that we are investing in the deal. Now, as an aside, and this goes between limited partnerships and co-tenancies or any investment, there's always a business question of cash calls. So this is a development project. On an income producing project, I'm going to invest $100,000, $500,000, $1 million. That's all I'm putting in. Cash calls, if the property goes sideways, it's an income producing property, multi-res or whatever it is, property goes sideways, don't come back to me for that. You can dilute me by getting money from other sources, from other investors. The difference though is on a development project, often there are cash calls, and cash calls are often mandatory. People going in know that there's going to be cash calls. This is a development project. Equity is needed to purchase the property today, but further equity will be needed down the road. Cash calls are mandatory. They are not voluntary. And if someone doesn't put any more money in, then they're usually to some type of penalties. Either they're diluted at a discount rate, or the money that's put in lieu of what they otherwise would have had to put in is put in as a loan at some high interest rate. So they may be future cash considerations that they will be putting into this project, but as a global concept, the liability is limited in that whatever they put in is at risk. Whatever they should put in the future is at risk, but nothing more than that. If I have a fabulous watch collection in my investment company, no one's going to be able to pierce that corporate veil, as I keep on referring to that term, and get to my watch collection.
Mm-hmm. Mm-hmm. And in the examples, going back to what you mentioned, in the examples that I've been exposed to, like you said, at day one, they say, okay, like you're going to be a partner. We anticipate that you're going to have to put in, let's say, $5 million, but over the course of 5 years, round one, we're just doing $1 million. We purchase the land, go through this phase, and then there is going to be more rounds coming in. But at the end of the day, your general commitment, your overall commitment is clear. You know when and relatively or roughly when you're going to have to put money in, and roughly when is the anticipated exit, I guess. I want to flip it a little bit and ask you, so this is a limited partnership agreement. Okay. Would you use a limited partnership agreement for more than one property?
Sure. So, one of the major concerns, especially in development deals where there's a lot more risk and a lot more potential for prospective issues arising, you want to segregate liability. We recommend to clients to always set up separate ownership structures for every separate deal. And this is whether you're buying donut shops or whether you're buying development properties, whatever it is you're buying, own things separately, because there's always something that inevitably will, like I said, it's an environmental and insurance claim that is beyond the insurance proceeds. It also provides you with flexibility in the future in case you want to sell off projects one from the other while segregating all that ownership. Or if someone is raising funds from potential investors, you may have different investor mixes for different projects. So you set up a limited partnership structure, a separate one for every single deal. You eventually, if someone has grand plans of creating, let's say, a REIT as an example, you can roll all those properties into a single structure on a tax somewhat efficient basis in the future, that you can still be provided with that flexibility. And the limited partnerships actually are probably more ideal if you have grand plans to create some type of REIT or central ownership structure and rolling everything in. But ideally, you do a separate ownership structure, separate limited partnership agreement per project.
I want to ask you to clarify some of the terms that we hear in the market quite commonly, and maybe walk us through the legal distinctions of what those means. I'm guessing most of them mean the same thing, but we're using different verbiages. One of them being a JV or a joint venture. I'm going to also ask you maybe to walk us through the REIT and why and at what point would someone consider even thinking about doing a REIT. That's probably a little bit more advanced. And I guess the other thing is that I know when you talk to many of the real estate investors, especially in the called the investment community, you hear a lot about putting together a fund. Do you see the LPGP? Is that the same definition, or are we talking about is there another definition we should be also talking about?
Everyone loves a good fund project or something along those lines. So that's more on the corporate securities level, but we've dealt with that for a number of clients that we have. So starting with your first term, a JV is a joint venture. So a joint venture is usually more akin, if you're getting into the legal nuances of it, of a co-tenancy. It's like a partnership on some level. It's an agreement as between various partners or joint venturers. And it's usually structured as a co-tenancy if you're getting into the legal nuances of it. There are some people that will say we use the term joint venture to say we are just doing something jointly with investors. So I'm going to be doing this project taking on this project as a joint venture, but really as a secondary measure, the structuring of it could be anything. It could be a co-tenancy, it could be a limited partnership. So joint venture in of itself is not it's not like you register a joint venture the same way you register a corporation or a sole proprietor partner. That's generally what joint venture means. In terms of REITs or funds that are a little bit more prevalent than REITs, there's a lot of work in terms of structuring a fund or a REIT from a corporate securities perspective. And if someone has a number of properties or has the objective of purchasing and or developing a number of properties, whether it's income producing properties, whether it's development properties, you can create a income producing fund, you can create a development fund where essentially you're rolling in or purchasing a number of properties within the fund. And there's two different ways that you can go about doing that. There's something called a blind fund, which basically means I'm raising $10 million now, and I do not have any properties yet. Give me your money. I will then go and source the properties and fill the fund with that equity. The other option is I have all these properties. I'm now going to roll them in and raise X amount of dollars into this fund. So, and I guess there's two different methodologies of doing so. The structuring, the nuances, the nitty gritty of the legal structuring could be the same. It could be, will be different. However, the end result is that you have a fund with property and you've raised a certain amount of money from investors and you take fees for, various things. For the raise itself, you can take fees on financing, you can take fees from managing, etc. There's a lot more work that's encompassed into that. Again, from a corporate securities perspective, depending on what level of disclosure you're using in the beginning. Is it an offering memorandum? Is it a prospectus? Accredited investor scenarios. You have exempt market dealers that you need to involve, and a whole host of things. We've done that for a number of our clients here at the firm. So it's definitely a more complicated process, but it's out there. It's definitely prevalent, and a lot of the big players do that. A REIT it's similar to a fund. in that the objective is the same kind of thing, right? Either it's a REIT of existing properties, and it's just the underlying mechanism, as opposed to a fund. It's a REIT, but it's the same idea. You want to have a whole bunch of properties under one type of legal umbrella for whatever reason. And clients want to sit down with corporate securities group. They can go through the benefits and the costs of doing the different types of structures.
Right. And sorry, just want to go back to the definition of fund. From a legal perspective, what does that fall under, like a typical corporation setup, or do you need to go through certain accreditation processes with like financial authorities?
So usually funds are actually structured as limited partnerships. Now there's trusts, there's like a mutual fund trust, there's different types of mortgage trusts and things like that. But for the most part, a lot of funds are structured as limited partnerships. And like I said before, if you have a whole host of limited partnerships owning different projects, it's more conducive to rolling them into a single limited partnership that then can be structured as a fund. The term fund isn't necessarily it's not like a joint venture. It's not a legal term that you go and register a fund the same way you register a corporation or a limited partnership. It's the collective term for raising money from a number of different investors, usually a much broader pool of investors.
Gotcha. So for anyone who's listening and you want to start raising capital, probably the best thing to do is to go and figure out everything you can and learn as much as you can about your LP, GP, and limited partnership setup. At least have an understanding, or go to talk to your lawyers and counsel just to wrap your head around it, because it seems like the most agile tool in your toolbox so far based on what we've talked about. With that being said, maybe, I don't know if it comes to top of your mind or not, but maybe walk us through one or two mistakes that you've seen people make, which has caused them grief, and people, like anyone who's starting new, what are the common mistakes they should avoid?
Well, I think the fundamental mistakes are not getting your business terms and the terms that you're offering to your investors straight from the beginning. So, as an example, all clients who, they want to start raising money from a number of different investors, they want to syndicate. Well, what are all those business terms, and how are you going to lay it out to your ultimate investors? Are you just going to type points out into an email? You're going to send them a WhatsApp message? Like, you want something that's a little bit more professional, but you want to make sure that you have everything down on paper. So before you don't want to incur a ton of legal costs initially as well, right? You're in the middle of doing your due diligence. You don't know if you're going to waive your due diligence and go forward with the deal. To start getting your lawyer to start incorporating a GP and setting up your limited partnership and drafting the limited partnership agreement and your property, that's going to cost a ton of money. And we are not cheap. I can tell you that. Our firm is cheaper than other firms. Our firm is cheaper than other firms, but we're not, at the end of the day, it's a lot of money and it's the client's money. And I'm not looking to retire anytime soon. I want to make sure my clients are with me for the long term. So their money and being financially efficient and respecting their money is important. So what I do a lot with clients is I say, here, let's put together a term sheet, 1 or 2 pages that sets out, again, the same thing like an LOI when you're looking to purchase a property. This is essentially a term sheet LOI for investors. Here's the term sheet that has all the primary business terms that you as an investor need to know. And then later on, once we've waived conditions, once I have your commitment, we'll put together our limited partnership agreement with subscription agreements and all that kind of jazz. So what goes into the term sheet? What are the primary things you should be aware of? You set out that it's going to be a GP-LP structure. You set out what is this investor's capital commitment? What are they committing? How much are they committing to put in? $50,000, $100,000, $1 million, etc. What is the distribution? Usually, typical distributions in terms of once profit comes out way back at the end of the project. First, money goes towards paying back everyone's capital that they've contributed. Sometimes include a preferential return to investors, and typically on development projects, 6, 7, 8% or so. There's no magic to it. It's really what people expect and what a promoter is willing to give. And then sometimes there's a catch up for the GP. A lot of times after that, then there's a split. Sometimes there's an IRR that's promised, but a lot of times after that, ultimately there's a split. And what's the split? Is it 75% to investors and 25% to the GP? After that initial hurdle, the preferential return is hit. Is it 80-20? Is it 90-10? Is it 60-40, 50-50? Again, there's no magic to it. As a GP, as a promoter, you want to get what you can and what people are willing to at the end of the day. And there's a lot more waterfalls that I've seen out there, but that's the basic distribution model. In addition to that, there's a question of mandatory versus voluntary cash calls. Investors want to know, am I going to have to put more money in? And if I don't, am I at risk from being penalized? A voluntary cash voluntary, you can put in if you want. If you don't, you're just diluted. So usually on development deals, it's mandatory. For regular type of real estate purchases, it's not always mandatory. So that's something that needs to be considered. What about guarantees, loan guarantees, surety guarantees, carry on, things of that nature? Do all the investors have to put up their proportionate guarantee? Mm-hmm. It's enticing for a guarantor to know that, no, you promoter, you're going to provide the guarantee for the collective project. Usually internally, there's an indemnity to say that if that guarantee is called, everyone has to indemnify as to their proportionate interest. But even with that, I don't want to put my guarantee on paper. If it's a smaller type project and there's only a few investors, sometimes they will all have to provide their guarantee. But again, it's a negotiation and it's a business term. In addition to that, there's something called major decisions. So do we give the general partner carte blanche to just do whatever they want in terms of the project, in terms of financing terms, in terms of selling the project? Or do we as investors want to have some control over what we call major decisions? And usually there's a threshold. It's not like we need that a general partner needs 100% approval from investors. Right. Usually it's 60%, 75% or so. You don't want to have to go to every single person to get them on board. But what are those major decisions? Selling, financing, bringing in other investors, raising new capital, dissolving the partnership, etc. It could be a laundry list. It could be a short title list, 4 or 5, 6 items. What fees am I charging as a general partner? Am I charging an initial investment fee? Am I charging a fee for financing? Am I charging a CapEx fee? Am I charging a management fee? If let's say it's an income producing property right now. So is there a property management fee? Is there an asset management fee? There's a whole host of fees that one can charge to their investors and put cash in their pocket that way. So all these things collectively, the objective is, what can I charge that people are willing to pay and willing to invest in my projects? And you can play around with a lot of these different business terms to get to the right model that will be sufficient for investors and enticing to them. So right. And getting back to your question, start with that term sheet. Same way it's an LOI. Term sheet, it's easy to read. That'll get you over that initial threshold to get your project going and get your investors on board.
And I guess that term sheet and having basically answered all these questions ahead of time will not only make your investment case more robust and solid in front of an investor, it would probably even help with the lending side of things. Maybe let's go into that route a little bit. What legal implications, and you mentioned the lending side of things. Maybe walk us through that. Do you have any pointers for someone who's going to go after getting money? What should they know about lenders? What their preferences are? My assumption is, again, the term sheet and everything you just mentioned would be very helpful to that process.
So the lending considerations are twofold, right? When you, in a development project, there's your initial financing, the acquisition financing. You're buying the acquisition financing from a lender. That lender may not be the same lender that gets you your construction financing.
True.
So later on, once you are ready to put shovel in the ground, you've got your zoning, you have your permits, etc., you're going to need construction financing. Construction lenders are a completely different game than the acquisition financing, right? Construction financing, if it's a condo project, you need a certain level of pre-sales. Again, you need formidable guarantors to back the underlying construction loan. What's the underlying loan amount that you can get relative to your costs? And that's going to play into your underwriting model in terms of how much money you have to raise from your investors, the equity side. Getting involved, or at least part of the underwriting process in the initial stages while you're doing your due diligence in terms of what the expectations are and realistically what kind of construction financing you can get is important. Don't wait until after you've purchased the property and say, I'll figure out my construction loan later. Figure that out before. Speak to construction lenders, even softly, to get an idea of what does the market look like? What kind of money can I get? And then build that into your underlying model during your initial due diligence.
I thank you for your time. It's been very informative. Do you have any final thoughts, anything that I should have asked you and I didn't, that you might find or you might think that our audience find it useful?
Not other than, I think it's a great idea. Anyone who's been doing, homes, makes that jump. You don't know what you don't know, but
Right.
go for it. Just be careful. And the consultants that you're going to, utilize, get them involved from the get-go. It's not cheap necessarily. It doesn't have to be overly expensive if you find the right ones, because they should be efficient. And a lot of people are willing to give somewhat of their time in order to help a potential client out. But don't be penny wise, a pound foolish and say, I can just do this on my own. So just be careful in terms of your documentation. There are a lot of options out there. There's a lot of structure. There are a lot of different lending options as well. You don't have to go only to the Schedule ones. We act, our firm acts for a lot of Schedule 1 banks, and they do fantastic construction loan work. We also act for a lot of Tier 1, non-Schedule 1 bank lenders who do a lot of construction financing. So there are a lot of options out there as well. And, do that underlying research, and hopefully you can make that jump, because it can definitely pay off well.
Thank you very much. And I agree that our discussion today reinforced my belief and our commitment that we need to do a lot of homework ahead of time before it gets to the point of pulling the trigger and committing dollars to the land. And this whole conversation and other conversations we'll be having on the podcast is part of doing your homework and hopefully being as prepared as possible for that moment. Thank you very much, Zev. I very much appreciate your time. This has been very informative. And who knows, maybe in a year or two, we have another one and we talk about new updates.
Why wait so long? Why wait so long? I'm ready. Whatever you need, man. Whatever you need.
I appreciate that.
Okay.
Thank you.
Have a good one.
Just one last thing before you leave. We've created a document called Real Estate Development Toolbox, which you can download for free from our website at realestatedevelopmentinsights.com. This document is basically the result of us asking our network and our listeners, what is a top tool that you use on a daily basis to keep yourself aware of information that's going on in the industry, the changes, the trends, the technologies, the regulations, or if you, with the tools that you use to make sure that you deliver quality results to your clients and customers, the tools that help you with productivity in what you do, and also any softwares, specialized softwares that you think are useful to share with others. So if you think there are resources that you're using on a daily basis and you would like others to know about them, please make sure to let us know, and we will make sure to include it in the next iteration of this toolbox. Thank you very much, and I hope you find this document useful.